Obviously, trying to fit them in.
There's only 6.
6. Okay, there you go. You're trying to fit all the cases that we had to review.
That was it.
Okay.
Why do you think that is?
Because you had these many cases.
Because it's nice broad.
No, it's just because it's the worst and you have to litigate it the most to see if your facts will fit in it. There are very few cases at the top. Oh, not missing anything. The worst facts make the worst law, right? Any other questions? Yes, sir.
Quasi and REM. In REM, it's pretty much always attached to property. Not always attached to property, but a thing.
Right.
So quasi and REM, if someone has a mortgage with a bank, then it would be that would where quasi REM would come in versus personal.
No, mortgage is still specifically about the property. Quasi and REM would be, my client's going to sue your client for breach of contract. Your client only has one piece of property in the state of Alabama that I can use to satisfy that judgment, which is not related to the breach of contract. So I want to attach that piece of property at the beginning of the case so that I can use it to pay off a judgment at the end of the case if I win my breach of contract case.
So would you ask the court when you attach it to file an injunction where they can't sell, that person cannot sell the property?
Either that or you file a notice over in probate court called a Liz Pendens, giving notice to everybody that that property is involved in litigation so that they buy it at their own risk. Yes, ma'am.
The purposeful availment, does that go under where you were talking about if you don't raise it and waive? Does that go with that?
Well, purposeful availment falls under what? Minimum contacts, right?
Right.
Sufficient minimum contacts? By definition, it would fall under number 6, right? Because you don't have it related to the act. That's number 5 and 4. It's not a resident, it's number 3. It's not served in state, it's number 2. And they didn't consent, voluntarily submit, or waive under number 1. So purposeful availment is one of the factors you consider under minimum contacts.
Purposeful availment, that doctrine generally applies in contract cases mostly. Is that true?
No, not always. Purposeful availment, if they're otherwise doing business here, if you have a tort that's committed in another state, but you want to sue them here in Alabama, if the act occurred outside the state, the injury occurred outside the state, they're not residents, you can't serve them here, and they're not going to consent or waive, how can you justify bringing them into court in Alabama? And the answer is, even if it's a tort that they commit somewhere else, how can you convince the court here to keep them here in Alabama? And that is, show what kind of minimum contacts they have. And if you can show they've purposely availed themselves of doing business unrelated to what the injury is, such that they're essentially at home in the state of Alabama, then you can justify personal jurisdiction over them under general personal jurisdiction based on sufficient minimum contacts. Does that help?
Yes, and this, purposeful availment, it also implies that the defendant's contact with the foreign state are deliberate, not accidental. Am I on the right track here?
Well, you
He
are.
must deliberately affiliate himself with the foreign state?
Well, you are, but don't try to connect it with what their activities are.
Okay.
Whatever gave rise to the lawsuit, if that was what you're suing on, then you wouldn't have to worry about purposeful availment because it's either under Hess versus Pulowski for causing an injury in state, or it's going to be an act done outside the state that caused an injury inside the state under Calder v. Jones. So the purposeful availment, they're doing business here, like if they're on the internet selling tickets to Alabama football games. Do you think they're specifically directing target toward Alabama? And if they're otherwise sued for some sort of tort outside the state, or they commit a tort outside the state, but you still want to bring them here, well, they're not residents, you can't get them to waive, you can't get them served here, and the injury is unrelated to their conduct in state or out of state. You know, the actions that get rise to it, the transactional occurrence, is not related at all to your case. Then the only way you can justify keeping them in the state of Alabama is, yeah, they're doing something here in Alabama. It's unrelated to my cause of action, but it's enough that they're essentially at home here. And then that would justify having general personal jurisdiction over them as a defendant. Does that help answer it?
Yes.
Everybody got that? It's the weakest form of personal jurisdiction you can get. But if they happen to move here and open up a bank account and start transacting business here, well, you've got a U.S. Supreme Court case that says opening up a bank account and doing business is purposeful availment. That's the Southern Pacific company that moved to Ohio during World War II. Benguet Mining, I think, is it. All right, any other questions? Yes, Mr. Francis.
How can you find out if they have a bank account if you don't get it from information in your communication with them? What are the resources to find out what their contacts are?
Well, you might have to hire a private investigator to track down if they've got any assets. You might want a skip tracer to find out where they've been. Or if you just want to play on dumb luck, go ahead and file the lawsuit against them and then ask the judge to allow discovery for purposes of determining minimum contacts. And then if they refuse to cooperate with the discovery, then you've got them. The judge can justify saying they're subject to personal jurisdiction for refusal to obey discovery. That's all they had. They weren't smart enough to say, we're going into this knowing that you have contacts. They went into it blind and just happened to luck into the fact that the other party was being obstinate and refusing discovery. And they ended up being able to use that to justify judgment against him.
Would they go under number 6?
That's kind of an exception to all of them.
I put it under, we haven't let them. I put it under waive because they didn't do what they were supposed to do.
Well, it technically is a minimum contacts case, and the judge found minimum contacts with refusal to obey discovery orders. All right, no other questions. Anybody come in after I called roll? Yes, ma'am. Ms. Washington. Ms. Washington, you missed us saying we only have 8 more weeks. And one of those is the exam. And one's the review, which means we only have 6 more weeks worth of new material. And this is 6 weeks, so we're halfway through. All right, this week we're going to talk about pleadings and parties. Now that you've got an idea that after the introduction you've got subject matter jurisdiction, federal courts week 2, state courts week 3. We talked about subject matter jurisdiction. We talked about personal jurisdiction. Getting them into court was week 4. Keeping them into court was week 5. And that's all your personal jurisdiction cases. Now we're going to start talking about pleadings and parties. And for that, I want you to go ahead and turn in your rule books, your federal rule books, to rule number 7.
What rule number?
7.
Thank you.
And we're going to draw you a little diagram to help you understand. All the parties and all the pleadings. Then they only left me with one color of, so one color is going to have to do. All right, if y'all haven't already covered this yet, there's a common abbreviation for a plaintiff, and that's the letter pi in the Greek alphabet. And you already have studied in week 1 that the way the case is commenced. You got it?
Well, I was trying, I couldn't see. So I was trying to zoom in.
All right, under Rule 4A4 in state rules, it defines plaintiff and defendant. I guess that's a good fundamental place to start. 4A4 defines plaintiff as the person who causes a summons to issue to another party. And then 4A4 also says that a defendant is the person to whom the summons has been issued. Now, when we talk about pleadings, and the pleadings under Rule 7A, those are all the pleadings that you have, there's generally 3 different types of pleadings. One type of pleading is going to set forth claims. Ordinarily, a plaintiff comes in with a gripe to court for which they're seeking official redress. And in that document that they file, they say, these are the claims that I have. That's the plaintiff coming to court saying, I have these claims. The defendant, in return, will have an answer which says, I'm responding to these claims, and they deny them usually, or set up some affirmative defenses as to why they shouldn't have to pay it. So you've got one type of pleading which is going to include claims, and another type of pleading which is going to include defenses. Everybody follow that? Claims and defenses. The third type of pleading is one that the U.S. Supreme Court basically has set up. It's called a reply. It's a reply to an answer. In discrimination cases like employment discrimination or gender discrimination, race discrimination, age discrimination, all of the types of discrimination cases. There was a U.S. Supreme Court case called McDonnell-Douglas. The same, oh, thank you. The same people.
I have no chill.
No what?
No chill. I have no chill. I'm not too.
Did they say anything when you walked in?
They didn't have any more. That's all they had. I saw that one out of her little.
Are they next door?
Sir?
Are they next door?
I went downstairs to the office.
Oh,
I
okay.
thought maybe that was, part of our.
I thought you just walked into another. You didn't just walk in on another class while the professor's up there talking.
She personally served.
Well, thank you, because this is going to help illustrate a little bit better. We're going to use pleadings themselves in red, and we're going to use the parties in green. So you can see the difference between the pleadings and the parties and how these pleadings get to be served up on parties. So where were we? All right, the 3 different types. You've got one that sets forth claims, one that sets forth defenses, and then the other one is the reply. The discrimination cases, the McDonnell-Douglas, usually the plaintiff will walk in and say, this person discriminated against me. And the defense to that is, oh no, we didn't discriminate. We fired you for this reason. And the employer will come in and usually say, we fired you because you weren't doing your job. And then the court says, well, you get to reply to that, where you get to say, hey, look, they nominated me as the employee of the month 12 times in the last year. And therefore, they can't say I wasn't doing my job because they recognize my excellence in doing the job. That this is really pretext and the reason they fired me was because of. So that's a reply. It's not often used, but it is a type of pleading. It's a reply to an answer. Yes, sir.
Yeah, I had a question. Being that Alabama's a right to work state,
You still can't fire somebody for an illegal reason.
You can give no reason, right?
Yeah,
you no reason.
You can give no reason. I'll give you an example. I had an attorney that I ghost wrote a brief to the 11th Circuit on. They had an employee that was a salesperson working at a big department store that got recognized as being Employee of the Month for several months. And then they fired her. By the way, it was a her, over 40, and different national origin. And you can't fire for any of those different reasons. So they fired her, and she went and applied for unemployment. And unemployment office said, okay, employer, is she really unemployed? And they said, oh no, we fired her for stealing. And of course the Alabama Unemployment Agency said, oh no, you can't do that. You know, you didn't prove that she was stealing, so they gave her unemployment. And then when she filed a discrimination case in court, she filed that complaint for discrimination based on age, gender, and national origin. And then the employer came in and said, oh, we fired her because she was doing substandard work. And the problem was they had already said they fired her for stealing, which the Alabama Unemployment Commission said, oh no, that's a lie. So then they tried something else.
That'd be it.
That's called judicial estoppel when you can't argue something different.
Then that'd be an EEOC claim? Would that be
Yeah,
federal,
EEOC.
state?
Federal court. And so yes, you can fire people for almost any reason, but there's some of them you can't do for an illegal reason. One of which is you went to vote. Another one is you have to serve jury duty. And that's specifically illegal to fire people because they have jury duty. And then there's the federal, which is the EEOC charges. Age, race, gender, national origin. And I think now they're even doing sexual preference or orientation, whatever you want to call it.
Before you file suit, you have to file, and the EOC or whatever investigates first. What is it? They investigate first.
They do. You file a complaint there.
And
They give you a right to sue letter.
One of my coworkers.
But the reason for telling you about the reply to an answer is not to get into the details of how to do employment discrimination, but to illustrate for you the fact that sometimes the court comes back and says, we want you to reply to this answer, where you get to say, no, I wasn't really fired for the reason they said here. Here's my evidence showing that I was employee of the quarter for so many times, or employee of the month, and they can't say I'm doing substandard work when the month they fired me, I was the employee of the month. Doesn't that sound like a lie?
Yeah.
So yes, you can fire for almost any reason, just not an illegal reason. So we've got a plaintiff who files a complaint. All right, I want to have two different defendants that the plaintiff is going to sue in this case. Is everybody all right with that? I'm going to have one complaint complaint is going to be served on each defendant. So I've got arrows going from my plaintiff box down to defendant 1 box and down to defendant 2 box. That is a complaint. It is the pleading that the plaintiff serves on the defendant. Has everybody got that? Ordinarily, it's going to be claims. However, you'll learn in this semester that there is an exception to that, where sometimes the defendant can file not claims but defenses. The plaintiff files defenses and then the defendants all have to come in and file claims. Let me give you an example about how they get confused like that. Y'all remember the airplane that crashed out here at the airport? Now, the insurance company who insured that flight may think, ooh, there's going to be a lot of people making claims. Let's go ahead and nip this in the bud. I guess dibs, right? First dibs. And they're going to go ahead and file the complaint in federal court, not because they have a claim against everybody that was on the airplane, or everybody that owned something that was on the airplane being transported, but because they have a limit to their liability, and they put the entire amount of the insurance proceeds into court. And what they do is they say, Judge, order everybody who's a defendant in this to make their claim toward this amount, and you decide how to divvy it up. Now that's called an interpleader that we're going to cover later in the semester. But that's an example about how you put the defense in your complaint, and then all the claims go in the answers. But ordinarily, you would have a claim goes in the complaint, and then the defendant has to answer against the complaint. So when we talk about complaints, it's not always somebody making a claim. Sometimes complaints are somebody making a defense. But there's still, it's still called a complaint. Because in order to commence your action, you have to file a complaint in the court. That's the most unusual thing in civil procedure. You file a complaint where it's not really a complaint, it's just a way to start a case so that people can make claims against the money. What would you call it besides a complaint? Judge, please get me out of here as fast as possible? Because that's really what they're doing, right?
Why would it not actually be like a bankruptcy or something? Where you said this is how much money there is, and then there's no more. And I mean,
Well, because if the airline is doing it, and the insurance company comes in and deposits the insurance proceeds in the bank, in the court, is there really more money? Yeah, you've got hundreds of aircraft out there owned by the airline. The insurance company's only putting in their limit of liability. Then you can still go against the airline and sell an aircraft to satisfy judgments. So it's really, Judge, just get me out of here as quick and cheap as possible for the airline's insurance company.
Why would the insurance, the problem get more payments, what the insurance company can pay attorneys to do it, they hopefully.
Right.
So they don't get an excess verdict.
So they don't get an excess verdict, but sometimes the claims may come in and make it an excess verdict.
Well, and that'll be against the property.
Oh, it's against the airline. And one of the things we're going to cover this week is real party and interest, Rule 17. You have to actually name the party whose money it is that you're trying to get at. And in this case, even though it's the insurance company that's suing or depositing the money on behalf of the airline, who do you think is named as the plaintiff? It's the airline. They're the real party in interest, not the insurance company. They only insured the flight. All the people who lost persons or property on that airplane are going to sue the airline, and not the airline insurance company. It's the airline that is at fault, not the insurance company. Real party in interest. Mr. Francis.
I had heard about a case similar to this, and it said that the airline was self-insured, and I wasn't sure. It seemed like the amount of insurance the airline had was kind of questioned. What is self-insured?
It is propaganda intended to make you believe that they don't have as many assets as they do. Does that make sense?
No, but the whole thing didn't make sense, but that kind of puts a piece to the...
All right, if I represent UPS and I come into court and say I'm self-insured and all the insurance I've got is $1 million, so I'm going to deposit $1 million in here, but then I've got $10 billion worth of aircraft on the ground, I am trying to convince you that all that is there for you to collect a judgment is $1 million I had in my self-insurance fund, right? Now do you believe it? You still believe it?
No, I mean...
I don't believe it either. That's why it's propaganda on this is all that there is to get. And in truth, it's not really all there is it?
Besides airplanes, they got the trucks, the buildings, and everything.
Yeah, they got a whole bunch of assets.
Yeah.
So don't let them use a fancy term of self-insurance make you believe that there's not more assets out there. All right, so the plaintiff files a complaint, and that complaint is served on each defendant. And remember, we covered 2 weeks ago that not only is the complaint served on each defendant, but also is a summons with each of their names on each summons, right? So that they get notice of the complaint. That actually requires them to come to court and defend against the action. Now, in Rule 7A, it lists that there is a second type of pleading, and it's called an answer. So we're going to draw an arrow from the defendant back to the plaintiff because the defendant serves the answer to the plaintiff. Everybody got that?
So the answer is filed from the defendant onto the plaintiff, correct?
Yes, and it responds to the complaint. In fact, an answer is called a responsive pleading. And it's responsive to what?
Complaint.
To the complaint. It actually is directly related to the complaint. Now, if you look at Rule 10, I think it's 10B, when you have separately numbered paragraphs in your complaint, your answer can refer to those paragraph numbers specifically in the complaint and say, defendant denies the allegations in plaintiff's complaint paragraph number 1. Plaintiff denies plaintiff's complaint paragraph number 2. So that they're separately numbered paragraphs. And the reason it's responsive pleading is because it responds directly back to the complaint, which is the document that got them in court to start with. So the answer is responsive pleading to the complaint. The reason that's important is because if there is a document to which a responsive pleading is required, or a pleading to which a responsive pleading is required, and you don't file a responsive pleading to it, then under the rules that's deemed an admission to everything that's in the original document that you didn't file a responsive pleading to. So they put them in pairs. For those of you in my science background, we'll call them tuples. They go in pairs. Now the next one, under Rule 7A, is that there's an answer to a counterclaim. All right, so where is the answer to a counterclaim go?
What, answer to a counterclaim?
Answer
So the
to-
defendant goes.
See, that's the funny thing is the rules skip a step, don't they? Before you get an answer to a counterclaim, you have to have a counterclaim.
Right, defendant is. So the
There you go. Flip over to Rule 13 real quick. Rule 13 tells you that there's two types of counterclaims. One of them is a compulsory counterclaim, and the other one is a permissive counterclaim. A compulsory counterclaim generally is one which arises from the same transaction or occurrence. Y'all remember that from week 1? Remember, the rules of civil procedure are designed to be transactional, which means for every set of facts and occurrences that are brought up in a complaint, if you have a claim that arises from that same set of facts and occurrences, if you fail to raise it, it's what?
Right.
Hence the term compulsory counterclaim. Compulsory because you have to raise it or else it's waived, and then counterclaim meaning that you're bringing the claim against somebody that brought a claim against you. Does everybody see that? And that's what I want you to put in your notes is what a counterclaim is. A counterclaim is a claim you bring against the person who brought a claim against you. A claim against a person who brought a claim against you. All right, so I'm going to draw a red arrow from defendant number 2 back up to plaintiff, and I'm going to call that a counterclaim. And the reason it's a counterclaim is because the plaintiff sued the defendant, and now the defendant's got a claim against the plaintiff, so they have to raise it in their pleading, or otherwise it's going to be waived because it's related to the same transaction or occurrence. Yes, ma'am?
Can you give us a quick example of that?
Everybody about this point in time asks for an example. So let me give you an example about this drawing in circumstances that would kind of relate to it. Let's say the plaintiff is a homeowner, and the plaintiff wants to do some renovations to their home, so they hire an electrician and a plumber. And during the course of their renovations, there was an electrical fire and a plumbing disaster. The homeowner have insurance, or the defendants have insurance? Well, whose fault is it?
It's the defendant.
Which one?
Both.
Actually, you may not know whose it is, right? So what does the plaintiff as a homeowner do when they have 2 contractors and there's damages that could be from both? Electrical damage and plumbing damage. You sue both. So let's just put a note up here. We'll call defendant 1 our electrician. And defendant 2 is going to be our plumber. Just so we can keep them straight, okay? Now, if the plaintiff sues the defendant, the plumber, defendant number 2, and says, you caused plumbing damage to my house, and they put that in their complaint. Defendant number 2 is going to file an answer either admitting or denying everything that's in the complaint and then setting up affirmative defenses. And then what if the defendant hasn't been paid for the work that they did? Is that related to the plumbing work?
You'll set a counterclaim for breach of contract.
A counterclaim for breach of contract, or a counterclaim for work and labor done or something, so it's related to the same work. So they have to raise it, or otherwise it's going to be waived. It's called a compulsory counterclaim.
Or he could counterclaim to the co-defendant that the electrician is the reason that the house burned down.
But now we're mixing up our terms, because a counterclaim is suing the person who sued you.
Oh, I got it.
Y'all got that? So now the counterclaim is going back from defendant 2 up to plaintiff. Now number 3 says an answer to a counterclaim. So where does that go? It's an arrow back from the plaintiff down to defendant 2. I'm going to draw it up on there for you so you see it's an answer to a counterclaim. Everybody got that? And you see the circumstances, how it may arise. All right, 7A3 is an answer to a counterclaim. Now 7A4, answer to a cross-claim. Well, they skipped another step. Before you can have an answer to a cross-claim, what do you have to have? You got to have a cross-claim. So now under our example of cross-claim, here's your definition of a cross-claim. A cross-claim is a claim you have against a party that's already a party in the case, but it's not the party that sued you.
So that would be from one defendant to another?
It'd be from one defendant to another.
And a cross counterclaim would be, say, defendant 1 then sues back defendant 2, right?
Well, let's say on our cross-claim, the electrician is going to sue the plumber, saying the only reason we had an electrical fire is because your plumbing caused a short, which caused the fire. Your faulty plumbing caused the fire. So we're going to label this as a cross-claim. And the cross-claim arrow goes from defendant 1 over to defendant 2. So the answer to the cross-claim is going to go which way? Defendant 2 back to defendant 1, because it's a responsive pleading to to the cross-claim.
Would this be where they would argue comparative negligence or something like that?
Not in Alabama, they wouldn't. Alabama is a contributory negligence state, not a comparative. Yes?
And these answers, are you saying they do that to the attorneys or they do that to the courts?
Well, if they're not smart enough to hire a lawyer, they got to do it themselves. Okay? Now, if they're smart enough to hire a lawyer, then their lawyers will actually prepare these documents for them. Now, generally speaking, you only get one shot at preparing your document, generally speaking. So if you're the defendant 2 over here that's got the counterclaim, and Alabama's got case law that specifically says this, if you've got a counterclaim to raise, then you have to do it in the same document in which you file your answer. Or otherwise, if you fail to raise it, it's what? So in your document, you're going to actually prepare something that says this is the answer portion of it, and then immediately below it is going to be your counterclaim portion. Now, what if the plaintiff who's filed their original complaint now gets back this counterclaim? Well, they couldn't anticipate that in their original complaint, could they? So they get a second document, which is going to be an answer to a cross-claim or a counterclaim. The answer to the counterclaim. But generally speaking, you only get the one shot.
So would the same be in the state of Alabama for the cross-claim from defendant 1 to?
Yes, if there's a counterclaim and a cross-claim, then the counterclaim and the cross-claim should be included in the same document as the answer. But in this case, the cross-claim is coming from defendant 1 instead of defendant 2. And if defendant 2 receives it after they've already filed their counterclaim, then they'll get to answer the cross-claim separately. All right, is everybody clear on that? Yes.
I missed something you said earlier. I did the whole thing. You said if a responsive pleading is not filed, then
It's considered to be admitted.
it's an admission. Okay, I make sure I got it right. Thank you.
You got it right. Yes, ma'am.
So the cross-claim is Rule 13G, right?
Cross-claim is Rule 13. 13A is counterclaim.
13G says cross-claim against the co-party. So that's the one that kind of goes between.
Yes, 13G is the cross-claim against a co-party.
Okay.
Now, let's go to the next step and say, what if the plumber actually subcontracted the work out? Instead of doing the work themselves, they subcontracted the work to another plumber. And then when the plumber gets sued, not only do they put a counterclaim in saying, oh, by the way, plaintiff, you haven't paid me for this work either. But don't you think if they had actually subcontracted the work out, they might need to add their subcontractor as a party?
So this is where joinder is now.
This is where joinder comes in. And this is called third-party practice, and it's under Rule 14. What you do well, first of all, let's talk about plaintiffs and defendants. The plaintiff in this case is the homeowner, right? Because they cause a summons to issue to the defendant electrician and the defendant plumber. And then the defendant electrician and the defendant plumber are defendants because they had a summons issued to them. Is everybody with me as far as the definition of plaintiffs and defendants?
Yeah.
Now, plumber has a subcontractor that he hired to come in and actually do that work, but the subcontractor is not a party yet. Y'all see a problem with that? How do you make somebody a party and responsible to answer a pleading?
Sure.
Sue them. But technically, what makes them respond to a pleading? The summons. So you have to issue a summons now to another person, which would be the subcontractor. But if you issue a summons, what does that make you?
Plaintiff.
Makes you a plaintiff. So now defendant number 2 is going to have 2 hats on. Not only are they defendant number 2, but they're also third-party plaintiff number 1. So we're going to make another box. Well, let's finish this. Defendant number 2 wears 2 hats. Defendant number 2, and then they're a third-party plaintiff. So we're going to expand defendant number 2's box for their title is not only defendant 2, but they're third-party plaintiff 1, or a third-party plaintiff, and we're going to put a 3P pie on it. 3P for third party, pie for plaintiff. And who are they going to bring in? I'm going to put sub P on here for subcontractor plumber. And the pleading from third-party plaintiff down to third-party defendant is going to be called a third-party complaint.
Say that again.
Third-party complaint.
No, the part before that.
Oh, the third-party plaintiff is going to file a pleading against the third-party defendant called the third-party complaint. And the only way that third-party defendant is responsible for answering that third-party complaint is they cause a summons to issue to them as well. You can't write that fast.
Okay. This is very confusing.
No, you want to know what confusing is? I had one case that had 31 plaintiffs and 31 defendants.
How did you keep up with
You draw a picture just like this to figure out where the claims go.
Everybody was suing everybody.
Everybody was suing everybody. But the problem is, only some of the third-party plaintiffs had claims against a specific third-party defendant. And then several of them had claims against a different third-party defendant. And then several of the third-party defendants had counterclaims against a different group of third-party, or different group of plaintiffs.
So where were you at?
I represented a dead guy. The best part about that was he never talked back to me. They cannot argue with you. And so they actually sued his estate. But there was insurance. We'll get into that in a little bit. That's where you contact the insurance company to say, hey, look, go do your job, while I sit back and watch. So that third-party complaint is going to be served on the third-party defendant, the subcontractor plumber. I put that in black up here on the board so we can keep track of who's our parties. Now, if the subcontractor plumber has received a third-party complaint, what do you think they need to file as their responsive pleading? A third-party answer, right? To assert defenses. So we're going to put another arrow up here going from the third-party defendant back up to the third-party plaintiff called a third-party answer. Now, what if the subcontractor hasn't been paid yet by the contractor?
Summons him to counterclaim.
It's a counterclaim. When you have a claim against the party who's brought a claim against you, it's called a counterclaim. You don't have to say third party. So the third party defendant may also have a counterclaim against the third party defendant. No, the original defendant, who's the third party plaintiff that sued them. That would be called a counterclaim.
So who
Okay, so they're doing back to the first one, the
Back-
initial?
The third party answer goes back to the person that sued them, which was the third party plaintiff, who happens to be the same person as the defendant number 2.
Right, okay.
That's why we put all the labels inside the box, that they are defendant number 2, but they're also third party plaintiff. Mr. Stokes.
How long do you have to file your counterclaims or answer to their complaint in court? How many days?
How many days do you have in federal court to file an answer? 21. Remember, we made that correction last week. It's 21 days. Not 28 that they originally announced. It's 21.
I know I'm not official, but can I ask a question?
Sure.
When defendant number 2 sends back his answer to plaintiff number 1, does he have to involve the subcontractor at that point, just so that the plaintiff number 1 knows there's a subcontractor?
Remember that you get one pleading.
Yes, so I would think yes. but
They
I
need
just
they
said-
need to put their claim against the third party defendant in there, and then they can serve the plaintiff with their answer with the certificate of service. But in order to get that third party defendant responsible to answer, they have to serve him with a copy of the summons. Ms. Myers,
So, it says 14 days.
you're looking at state district court.
No, this is Federal Rules of Civil Procedure. This is the, no, this is the Federal Rules of Civil Procedure. This is the timing, is this different, the timing of the summons and the complaint? About more than 40, so.
Yeah, you're trying to get leave in court to file a complaint. If you do it more than 14 days after your original answer. You've got 14 days built in to file the summons against the third party. You should do it all at the same time. But technically, you have 14 days after you serve your answer. All right, now, is everybody clear on what the difference is between a counterclaim and a cross-claim?
Yes.
All right, what if?
Yeah, I've been what ifing on this all the time.
Oh yeah, we what if on this the whole time.
Yeah.
What if the reason for the whole fire is because the plaintiff's child actually went in and got mad at the subcontractor and took an axe to the plumbing and destroyed the plumbing, which caused the electrical fire and the water damage?
Negligence by negligence.
Yeah. How do you take it back?
Against the plaintiff.
You can't undo an axe. So who does the subcontractor bring a claim against? The plaintiff, right? Okay, and what would you call that document?
Third party counterclaim. Third party counterclaim.
Hold on, who said cross claim? It is a cross claim because you're suing somebody who's already a party, but it's not the person that sued you. So when they bring that claim up here against the plaintiff, it's going to be called a cross claim. And they may well file a counterclaim to that you should have marked it off safe from my child so they wouldn't get involved in your work.
Can I complicate it more?
Yeah, go ahead, complicate it some more.
Okay. The subcontractor plumber finds out through discovery that the water did come down and short out the building, but the electrical contractor was using people that were not certified to do electrical work in the city of Birmingham.
All right, so the third party defendant, who's the subcontractor plumber, wants to bring a claim against who? The electrician?
Yes.
All right, so what would you call? That's still a cross claim, right?
Cross claim, yeah.
Because it's a claim you're bringing against a party who's not the party that sued you.
Right.
So there's the key things you need to learn about these pleadings is you've got responsive pleadings. For one pleading, there's supposed to be a second. It's called a tuple. So a complaint and an answer. And then a counterclaim and what? An answer to a counterclaim. A cross claim and a what? Answer to a cross claim. And then a third party complaint and a what? third-party answer. So for every document that's filed in court, you complaint and answer, counterclaim and answer to counterclaim, cross-claim and answer to cross-claim, and third-party complaint and third-party answer. And then those are called responsive pleadings because one responds to the other. And the general rule is that if it's a document to which a responsive pleading is required and you don't deny an allegation in the first pleading, it's deemed an admission in the second.
Is there a time period?
Is there what?
There's a time period to respond cross courts. Is it the 21
Yes.
days? Is it 21 days?
21 days in federal court.
What was the 14th we can sign?
That's if you serve the third-party complaint after you actually file your answer. You got 14 days to serve it afterwards. The better practice is to go ahead and do it all in the same document. Everybody got that? That's the most difficult part of civil procedure, is figuring out what's 14 days to serve. 14 days to serve a third-party complaint if you don't put it inside your original responding document.
You threw out the term, somebody said joinder, but we didn't talk about it much. Is that when the?
Oh, joinder is how you join in parties.
That's
Like,
when the defendant became a third party plaintiff?
yes,
At that point? Okay.
they joined another party. Now, there's, yes ma'am.
No, it's okay.
No, we'll get to that later. Interpleader is where the insurance company puts the money in court and says, y'all make the claim. We'll get to that in a couple weeks. Yes, Ms. Massey?
You said 14 days to file a third-party complaint if it wasn't in the initial document?
Right. And that's under Rule 14. No, these are all still diversity. And when you look at Rule 13 about your cross claims, it says that, on your Rule 14 in your third party practice, it says you can join them as long as it won't destroy diversity. And if it destroys diversity, you're going to have the court determine, are they needed for a just adjudication? Because if they are, they'll probably dismiss the federal court case and then you'll have to refile it in state court. Yes, ma'am.
So when you filed the motion for judgment on the pleadings, is that one of those instances where you have to use the numbers for the lines in your response? Okay, so.
You're 2 or 3 weeks ahead of us right now.
Oh, okay.
We haven't even gotten to responding to pleadings yet. Right now, we're just getting the initial pleadings to the initial parties. Yes, ma'am.
Is that federal?
Yes.
So I can state it because I read some California on the 30.
That's federal. What you need to learn is federal.
Okay, I'm just.
Yeah. The state rule has a different timeline in it, but we're not going to worry about that for the exam or the bar because all they're testing on is federal. Yes, ma'am.
Did you say something about a towel?
A what?
Towel?
Yeah, tuples, pairs. Pairs. The complaint and the answer is a pair. T-U-P-L-E. Yeah, tuples.
You said that admission in the second. Can you repeat that statement? Admission in the second.
Now, if you omit denying something in a responsive pleading, it's going to be deemed to be admitted. And we'll get to that in a minute. We're coming up on it. Right now, we're just trying to show you all the different parties, because up until this point in the semester, all you've really been worried about is the plaintiff. Picking the right courthouse, making sure that you can get jurisdiction over a defendant, not only how to get them into court, but also how to keep them in court. And now we're talking about all the different parties that are going to be involved or can be involved. And right now, just the plaintiff with an electrician and a plumber, heck, that's an easy example. But it's really the same type of example like if you have a multi-car pileup like happened on 65. This is the person whose car first got hit in the rear end, right? Who did they sue?
Everybody behind them.
The person that hit them. Who does this person sue? The person that hit them. That's the third-party defendant, who may also be another third-party plaintiff to bring in the person that hit them. Are y'all seeing the pattern?
Yeah.
Now, can the plaintiff also bring in the person that started the whole thing? They could, but do they have to? Did their car technically hit them? So whose job is it to bring in that defendant?
The person who's last sued.
The person who was last sued or the next to last in the chain, right?
This is more of a linear growth than an exponential.
Yes. You don't want exponential growth in federal court. Now, has everybody got how to bring the parties in and why you would do it like that?
Yeah.
Now, there's a term that you need to be familiar with, and that is that the plaintiff is the master of their complaint. The plaintiff is the master of their complaint. Now, why do you think you use such a term like that?
They control.
Because they control their complaint. Who else is drafting up the plaintiff's complaint except for the plaintiff? Nobody. So how many different claims can a plaintiff put in their complaint? As many as they want to. And if you look at Rule 18, that's exactly what Rule 18 says. You put as many claims in your complaint as you want to. Now, let's talk about the multi-car pileup on the interstate. How many defendants can you name in your complaint? As many as you want to, and that's Rule 20. Y'all didn't realize that, but I stuck 2 more rules on you in under a minute. 2 more rules in under a minute, 18 and 20. Now, if you go back to Rule 19, it says that you have to join all the parties that are necessary for a just adjudication. And that's important because if you refuse to join somebody who's necessary, and the court can actually add them as a party and have personal jurisdiction over them, but you refuse to add them, and they are necessary for just adjudication, you know what the court can do? They can throw your case out.
The whole thing?
The whole thing.
What is adjusted?
That's why Rule 19 says that they are necessary parties. That means you have to bring them. If it's related to the same transaction or occurrence, you don't have a choice. You've got to bring them as parties, or otherwise the court can throw your case out. So while it's your choice to name as many parties as you want under Rule 20, you have to name the bare minimum set of them under Rule 19. And then at that point, when you've got all the parties joined that you have to be joined, you can assert as many claims against each of them as you want to under Rule 18. Yes, ma'am.
What is adjusted adjudication?
Just?
Well,
It's
adjusted, what is that terminology?
a just adjudication. A fair.
Oh, I thought you were saying adjusted.
No,
So
a just.
It's a just.
Remember Rule 1, just, speedy, and inexpensive determination? So it's a just adjudication. And the plaintiff is the master of their complaint, which means they get to name as many parties and as many claims as they want. And then I'll tell you that there's a term for when you bring too many claims at the same time, that they're just not related to each other. What if I've got a claim for a breach of contract that I want to bring the same time I bring a car wreck against a different person, the same time that I bring a claim against my neighbor for trespassing on my property? It's weird, right? Why would you want to put all those different claims in one complaint? Pay court costs. You don't want to pay as many court costs, so you bring claims against your entire neighborhood in one complaint. Well, let me tell you how it was historically handled. Back before 1938, when they had equity rules, instead of the rules of civil procedure in federal court, be somewhere around 1973 in state court. When you brought too many claims against too many parties that were unrelated transactions or occurrences, the term for that was called a multifarious complaint. M-U-L-T-I. This is something you can impress your friends with. M-U-L-T-I.
Is it impressed test?
Oh yeah, it's a good test question too.
All right, there we go. Lead with that.
Right, various.
F-A-R-I-O-U-S. M-U-L, multifarious. Multifarious complaint. A multifarious complaint is too many unrelated actions inside of one. Now, historically, what the federal courts would do with a multifarious complaint is dismiss it, because it was too many unrelated claims. Now that the rules of civil procedure have been adopted, what they do is they usually split them out into separate cases. Well, you're not supposed to. That's why they would dismiss it. And then now the traditional to dismiss it has been overcome by the modern, which is to separate them into separate trials. They make you pay a filing fee for each one. You know why they make you pay a filing fee for each one in state court? Make money, but why do they want to make money? Why do they make you pay separate filing fees in state court?
To discourage.
All right, here's the thing. Do you know how court costs are actually broken down and how the money is divided?
No.
Well, when you look at the legislation, part of the filing fee on each case, I think it's like $8, somewhere in there, goes to something called the Fair Trial Tax Fund, which is where they pay court-appointed attorneys to represent indigent defendants. So a portion of each court cost goes to that. On criminal cases, a portion of that court cost goes to the district attorney's fund. But then there's a large portion of each court cost that goes towards judicial retirement. And if you want to find that, that's under Title 12 under courts. Just look for the chapter on judicial retirement. It tells you the portion of each court cost gets set aside for that. That's state court, by the way. Federal court, they don't do that. All right, any questions about multifarious complaints?
Do they not do that because of lifetime appointments?
That might be a good reason. They don't have to have that. And in state court, they need to be reelected. Yes, ma'am.
So after a multifarious and the court dismisses it, can they come back and separate it now?
No. That was traditional. They would dismiss it back before 1938.
Okay.
Now, the modern approach is to order them to be split up into separate cases. They can separate it out, but the better practice is don't file multifarious complaints.
Do they do like a causality test to determine interrelatedness?
What they look at is whether or not it's the same transaction or occurrence that underlies the facts of each different claim that's in there. Because if it's the same transaction or occurrence, then they are compulsory claims. You got to raise them or else they're going to be waived. Compulsory claims as well as compulsory counterclaims. If you fail to raise those, then they're waived.
What does it mean when you have fictitious defendants?
Fictitious defendants are under Rule 17 in Alabama. They don't have fictitious defendants in federal court. What you do is you file a complaint, you name somebody as a fictitious party, and sometimes they're fictitious party number 1 or fictitious party A. But in the complaint, you describe what this fictitious party did, and you say, I don't know their names, but when I find out their names later, I will substitute their names in for the fictitious party designation that I've used to describe them in the complaint. If you have a hit and run and you don't know who did it, you go ahead and file the lawsuit against somebody before your statute of limitations runs.
I've seen that done in a divorce where a adult, she was claiming that he was cheating.
And didn't know who it was.
She wasn't sure of the name, but we found out.
Oh, wow.
So I read
Oh, that's cool.
got rear-ended. And so
This is a friend, right?
Yeah.
All right.
Yeah. Had a motor vehicle accident. There was a rear impact collision. Reworded. But anyway, so he's sued, and it's a money grab. But he's got like 20 fictitious.
Holy cow!
For all the people who caused the person to run into the back of?
Exactly. Yeah.
Okay.
So by the time, if those parties are not identified, by the time it goes to trial, then are they
Dismissed.
Okay. That's what I was.
Fictitious party practice in Alabama, by the time it goes to trial, if they're not added, they're dismissed from the case.
Is that just a, like, because when I read it, I'm thinking, how can this even, is that just posturing, like, in the initial complaint?
No, it's to preserve your claim, because if you're close to the statute of limitations, you have to file against somebody before it expires.
Right.
And then you do your best to try to find out who it is and get them served.
But is that a common number of fictitious, like in that type of?
They vary.
Because this was like, both parties drove off, I mean, it was not a serious wreck. And I remember that's just sketchy, like shady, you know?
No, it's called cover your bases, because what if it turns out you find out who it is and you don't sue them?
And you're millionaires or whatever.
Yeah, and you're the attorney and you don't sue them, or you don't make provisions to have them added as party. Who does the client go against then?
You.
They go against you.
Yeah.
So in third party practice, if you don't know who it is, name them as a fictitious party, but that's only in state court. Federal court does not allow fictitious parties. Now, I say that, but then in your criminal law case or your criminal procedure case, you're going to find out that there was this lawsuit against 6 unnamed officers. They filed it in federal court. And it's called a Bivens action, where you don't know their names. Bivens, B-I-V-E-N-S. So while you can't name fictitious parties in federal court, you can say that they're unidentified parties. 6 unidentified FBI agents is, I think, who they sued. But we'll get to that in a minute with the Ashcroft case. All right, any other questions about the pleadings? Did you look at Rule 14, third party practice? There's one more thing you need to get out of that. Remember, the plaintiff is the master of their complaint. So who do they get to add as defendants to their case?
Anybody they choose.
Anybody they choose, right? And anybody that the plaintiff chooses to add to the case is going to be a defendant, because they're going to serve a summons upon that person and require them to come to court and defend the action. Now, third party practice from the defendant's viewpoint is that if you've been added as a party but somebody else is actually responsible for it, then you get to add them as a party, and this is called joinder. You get to join them as a party. And that's because you weren't originally the one that brought this to court. You didn't have the right to control who got added as a party. So they add the ability to add parties under Rule 14. Now, can the plaintiff join another party?
After the initial filing?
Yeah, after the initial filing, can they add another party?
You just said
But then now, then they have to
Then
do,
what's the point of covering all your bases?
But they went back to
Under discovery?
within the same claim?
All right, here, yeah, within the same lawsuit.
No, they waived
They
it.
have to do it in the initial documentation.
Yeah, they should have put it in the original documentation, and they would have been called a defendant because they would have had a summons issued to them as an original defendant.
So the only way,
But Rule 14 allows a plaintiff to add another party after the original complaint's filed. When a claim comes in against the original plaintiff, that may cause them to have to join a party if they're responsible. So where this one comes in and says, the subcontractor plumber comes in and says, "Oh, plaintiff, it was your kid that caused all the damage." And the plaintiff says, "Oh, no, it wasn't. It was the boy next door." Ah, now we got to add somebody.
So does it have to be a cross claim?
There would be a third-party plaintiff. The plaintiff would also be a third-party plaintiff because they're adding somebody after the original complaint.
But do they have to issue a new summons?
They have to issue a new summons to, they have to issue a new, no, just, it's not an alias. It's a brand new one because they're a brand new party.
And everybody has to be named on it at that point, or just the additional person?
Just the additional person. Because they're the only third-party defendant that's being named in this in response to the fact that the subcontractor plumber asserted a cross-claim against the plaintiff for their child's damage to the property. But really, the plaintiff comes in and says, "Oh, it wasn't my child, it was the kid next door." So they join the kid next door as a party. And yes, if the child's under the age of 16, then the parent and the child, no, the parent has to be served. And then if they're 16 or over, the parent and the child has to be served. But that's under Alabama rules for serving a minor. Remember, your federal rule on serving minors in incompetence is follow state law. Is that simple an answer for you for minors in incompetence? Everybody got that?
Yeah.
Now, do you see how we can keep adding people all day long? Let's stop adding people.
What was that line?
Oh, it's going to be a third-party complaint.
So it'd be just like defendant 2 suing the subcontractor, correct?
Yes. And then I'm going to put neighbor kid on there just to remind you that it wasn't my kid, it was the neighbor kid that did it, right? You see how this could go on forever. Yes, Ms. Gary?
So if the subcontractor is filing, saying that it was
The plaintiff's child.
The plaintiff's child. And then they realize it was, that's the joiner.
That's the joint, well, that's where they're making a cross claim.
They're making a cross claim.
And then the plaintiff has joined her for a third party because a new claim has been brought up after the original.
So the plaintiff has a joiner,
Yes.
but the joiner is still a brand new claim.
So,
Look at, I'll show you exactly where this comes up. Look at 14B3, plaintiff's claims against a third-party defendant. The plaintiff may assert a claim against a third-party defendant. Any claim arising out of the transactional occurrence that is subject matter of the plaintiff's claim against the third party. The third-party defendant must then assert any defense under Rule 12 and any counterclaim under 13A, and may assert a counterclaim under 13B or a cross-claim under 13G. Almost. I'm not there yet.
Which rule that is, Professor Bodie?
14A3. Plaintiff's claims against a third-party defendant. Now, have we covered everything we need to on adding a party and the names of the claims that goes against them, the claim or the pleadings? Look again at 7A because we're finishing up the different names of pleadings. We have a complaint and an answer to a complaint, an answer to a counterclaim designated as a counterclaim, which means you've got to have a counterclaim and an answer to a counterclaim. An answer to a cross-claim, which means you have to have a cross-claim and an answer to a cross-claim. Third-party complaint, an answer to a third-party complaint, and if the court orders one, a reply to an answer. That's the only one we don't have up here. So if the answer comes back up from defendant 2 to plaintiff, the court can order a reply to an answer.
So how many people have to answer?
That's the last pleading. The court can order that the party file a reply to the answer.
Is that to all defendants or just?
Technically, for any answer that's out there, the court can order a reply to it. So if there's an answer to a third-party complaint, they can order a reply to the answer. If there's an answer to a counterclaim, they can order a reply to that answer. An answer to a cross-claim, they can order a reply to that answer. Depends on which party's raising the issue to which the court wants a reply to it. That's the reply to the answer. And I'm only putting one up there instead of one for every one. But there could be one for every one.
What's that called?
If the court orders it, it's a reply to an answer. It's the last one under Rule 7A.
And the purpose of that
7A7. That's it, 7A7. And the purpose is what?
And the purpose is for the court to sort of get an idea of really who needs to be involved with this and who doesn't?
Yes.
Okay.
Or if in the answer it raises some sort of culpability issue, for the court to get an official response to that allegation of culpability. And that would be applicable to like the discrimination cases. We're not culpable because, and then the court can answer a reply to that question of culpability. All right, now we're going to get to real parties in interest, which is our Rule 17. Now that we know all the different parties and all the different pleadings, who's the one that brings the actual pleadings themselves? All right, the plaintiff brings the complaint, right? So is it the plaintiff's child who brings this, or is it the homeowner themselves? All right, so what if the child was injured as a result of the fire that was caused by some sort of water damage, and the child is the one who's injured instead of just the house being burned down?
The child
Can the child sue themselves?
The adult bring it on behalf of the minor guardian.
Right. The child can bring it, but the child wants to.
Yeah, you can't sue yourself either. It's not truly adversarial if you sue yourself, right? Unless you have multiple personalities.
I was going to say something. John Casey.
All right, so what if the child's injured? Do you bring the lawsuit in the name of the child, or do you bring the lawsuit in the name of the parent?
Over 16.
All right, there's two concepts that you need to be aware of. One of them is called standing, and standing is the right to bring the suit. And the second one is called the real party in interest. And a real party in interest is the one who's actually damaged, or the one who has a financial stake in the outcome of the case. A lot of your cases will say they're the ones with the financial stake. S-T-A-K-E, stake. So, stake. Oh, standing is the right to bring it, and real party in interest is the person who has a financial stake in the outcome of the case. Stake, S-T-A-K-E. I'm hungry, so I'm thinking of S-T-E-A-K. But it's the one who has money to lose, essentially. So, if the child was the one that's injured, who has the right to bring the lawsuit from a standing perspective? The parent or guardian, right? But whose name goes on the complaint up here at the top? The child's. And why does the child's name go up there? Because they're the real party in interest. Now, but the child doesn't have the right to bring the lawsuit. Huh?
So,
The parent or guardian or custodian has the right to bring it, which is standing, but the real party in interest is the child who was injured. So the lawsuit is,
parents have financial stake.
not if the child's the one with third-degree burns all over their body.
The parents be the one to pay for the healthcare bill.
Maybe.
Child was the one that was damaged.
The child's the one that's damaged.
So if the child was,
They're not old enough to
hurt,
5-year-old.
Yeah, the child's not old enough to sue is exactly right.
up to age 16?
No, until 19 in Alabama. Age majority.
So they would, if the parents were the people that the child had to bring action against, then does the court like
No,
assign a guardian?
the parents are bringing it on behalf of the child.
Oh, okay.
So what you do in the name of the complaint is you put the name of the child as the plaintiff by and through their parent, guardian, or next friend, and then you name somebody who has the right to bring it. So you're actually naming the person that's injured and the person who has the right to bring it as the party in the case. So who's the real party in interest in here? It's the child. And that's where you're going to answer your questions about who's the one that I'm suing for, and it's the one who's injured. Who has the right to bring the suit? And that's going to be that sometimes is a question. So which parent is it? Is it the daddy of the child that has the right to bring the lawsuit? Is it the daddy who has the right? What if the parents were never married?
Whoever has custody.
Whoever has custody. So who has the right to bring the action on behalf of the child? The custodial parent. But sometimes you'll see where the non-custodial parent brings the lawsuit on behalf of the child. Well, that's when you have to question whether or not that person has standing to bring the action. Not whether or not the child's the real party in interest, but whether that person has standing to bring it. And in Alabama, the case law is generally almost anybody can bring an action on behalf of the child. But the court needs to make sure the right person gets the money to hang on for the child.
Do they always appoint a guardian ad litem?
Hold on, we're getting to that. We haven't used the term guardian ad litem yet. So, let's talk about it now. What if the non-custodial parent does bring the action on behalf of the child? The child may need somebody to look after their best interest, and the court technically could name a guardian ad litem to handle the case for the child. Or, more accurately, what they'll do is they'll probably remove the non-custodial parent and bring in whoever the custodian is, because the custodian really is the one who has the right to bring the action on behalf of the child. All right, so now look at Rule 17D in the state rules. State Rule 17D, every minor who is sued automatically gets a guardian ad litem. Every minor who is sued automatically gets a guardian ad litem in state court. And why do you think that is?
If they're sued, or you come out like?
If they're sued, if they are a defendant.
Do they automatically get a guardian?
Hold on. If they are a defendant, they automatically get one. Who's going to bring the suit in the name of the minor as a plaintiff? Parent, guardian, or next friend, or whoever it is, right? So they don't get a guardian as a plaintiff. They automatically get one as a defendant. Go ahead.
That gets into my question is, what if you have a non-custodial parent, you get all the way to trial, retribution, and then you finish all comes up trying to say he's not the real party in it.
Oh, but the child was the one who was really injured. It's just that the party doesn't have standing to bring it on behalf of the child.
What about a corporate situation where you have an owner of a piece of land and a rental agency, and you brought in a rental agency, but they don't own the land?
Do they have the right to bring the actions on behalf of the land? Here's the rest of Rule 17. Flip open to Federal Rule 17. Federal. If you look at the real party in interest, it is an action must be prosecuted in the name of the real party in interest. The following may sue in their own names without joining persons for whose benefit the action is brought: the executor. So you don't have to bring the name of the decedent in. The executor can themselves as the executor of the estate. The administrator, the guardian, and letter D, the bailee. Now, what is a bailee?
Person who drives it.
A bailee. Is that the guy that got out of jail? Bailments is what we're talking about. You have a bailor and a bailee. A bailor is the person who owns a piece of property that gives it to the bailee for safekeeping. So, who has the right to bring the action if I'm responsible for holding on to somebody's property? Well, technically bailees apply to personal property, but then look at letter F, a party with whom or in whom name a contract has been made for another's benefit. So the contract is for the management company to take care of the property. So the management company can bring it on behalf of the property owner.
What number was that?
It's 17A1E. Federal. 17A1E. So generally, if you're protecting something for somebody, you have the right to bring it in your own name. Does that help your question? And then letter E, no, that was F, party in whose name there's a contract. E is the trustee of an express trust. So do you have to name everybody who's a beneficiary under the trust? No, the trustee's enough. But that's under the definition of a real party in interest. Capacity to sue or be sued is under B. Now, do minors have the capacity to sue or be sued? No, that's what minority and incapacity is. How about somebody that's incompetent? Again, no. They don't have the capacity to sue or be sued. So you name somebody else as their guardian, or if there's no court-appointed guardian, their caretaker in fact. Remember the person you have to serve with the summons and complaint against an incompetent? You name that person as the party on whose benefit they're protecting their ward. What's that?
What about like an incompetent person? Yeah, I mean, but no, like I guess what I'm getting at is like somebody that maybe be like a ward or be, I don't know, at home or something that doesn't have siblings or parents. It's just about this. So
well, actually, it's addressed in the rule. If you look at minor or incompetent under C, those with an official representative and those without. C2 is those without, where they're being cared for. Then you name that person as the party, because you have to have somebody who can actually fight. That's the nature of the adversarial system.
So if a guardian ad litem is representing, like he was saying, an incompetent by myself, I have no one, and they win some lawsuit, monetarily wise, where does the guardian keep that money? I mean, eventually they have to give it to them.
Okay, y'all, we've been bouncing this term guardian ad litem around, and I don't think we've defined it yet. Let's define it real quick. What is a guardian?
Someone who looks out for someone's interest.
Someone who looks out for somebody else, right? Now, what does ad litem mean?
Temporary.
Ad litem is a Latin phrase which means for this litigation. So what is a guardian ad litem? They are the guardian for this litigation. Sometimes they are expensive. Sometimes they're cheap. So what do you think a guardian ad litem does in a case?
Take pictures of the child.
They protect the interest of the minor or the incompetent. Now, what do you think an administrator ad litem is?
They're administrator of this litigation. Whatever happened in that litigation.
They're the administrator for that litigation. Now, when do you think you might have an administrator ad litem?
When there's an award.
All right, let's talk about this car wreck again, okay? The plaintiff is going to sue the defendant for running into the backside of their car. But then they realize that in the 2 years that they've waited to bring this lawsuit, that defendant has now died. So can you sue a dead person? All right, let's rephrase that. Can a dead person defend themselves? So you don't have a truly adversarial situation. So federal court doesn't have a true case or controversy because you have a defenseless party. Everybody follow? You sue the estate. So you name the estate because the estate is somebody that can defend themselves. So you go down to probate court and you look it up and you find out, have they opened up an estate? And the answer is no. So there's no estate to sue. How do you sue them?
Filed, let it go.
Well, Mr. Francis.
Maybe they haven't filed, they haven't opened.
I'm going to tell you that a file folder is just as defenseless as a dead body.
Can you sue like your next friend?
How can a file folder defend themselves? Who do you sue? Here's the trick. If y'all want to do plaintiff's work, here's the trick. If you've got somebody that caused an injury and you want to sue them, but they have since died, the first thing you're going to do is go down to probate court and find out if an estate's been opened. If it has, you name the person who's in charge of the estate. But if there's not been an estate opened, how do you preserve your client's right to go forward in that case? What you do is you sue the dead person by name, and then you file a motion with the court asking the court to appoint an administrator ad litem for that case, because there's been no estate opened up that you can find an administrator for the estate to sue.
So it forces them to.
And that's perpetual.
It forces them to hire or to appoint somebody to defend, and then you've got an adversarial case. Now, I've been every once in a while appointed to represent such dead people. What do you think the first thing you do is when you get appointed to represent such a dead person? You call your client. Just kidding. That would be a seance. We don't teach you how to do seances at law school. So what's the first thing you do? You file a notice of, you file a notice of appearance accepting your appointment. And then the first thing I do is I call the plaintiff's attorney and say, hey, look, you just caused me to be appointed on this case. What the heck are you doing? Did this person have insurance? And if so, tell me who's the claims adjuster so I can write them a letter and say, I represent the decedent who has an insurance policy under you for which you have the duty to defend this lawsuit. Do your job. And then second paragraph is, I demand that you settle within policy limits so that I'm protecting the estate from anything above and beyond what the policy limits are. You follow that? That's part of the administrator's job, is to protect the estate. And if I demand that they settle and they don't, the estate might have a bad faith action against their insurance company. You follow? So your job is to make sure there's somebody there to fight, and if they had an insurance policy, you get the insurance company to do their job that they've been paid to do with the insurance premiums. Now, what do you do if there's not an insurance policy?
Figure out what else they might have had. Maybe they had a house.
Can you go file a bankruptcy for them? No, dead people can't get excused from death. You got to search and see whether or not they have assets. And then if they do have assets, and you find out that there's heirs, then you may want to go ahead and have an estate opened up in probate and have that 6-month claims period opened up so that if nobody makes a claim in 6 months, you protected the estate. And then if somebody makes a claim to the estate in 6 months, then you can contest the claim and make them prove their case. Yes,
I
ma'am.
just want to go back for a second. Alabama Rule 17D does not have a federal counterpart. Is that what you said?
17D is which one?
The guardian at
Yes, federal courts do not automatically appoint guardian ad litem. They do not automatically appoint. Now, if you're going to sue a minor in federal court, what do you think the most prudent thing for you to do would be? Motion to appoint a guardian ad litem? Find somebody to defend the child, the minor or the incompetent, until they have a parent or guardian step in?
What if they'd be better served by a guardian ad litem?
That happens.
Why is it the plaintiff's responsibility to have the minor have a guardian ad litem?
Okay. If you raise an issue, what do you have to do? Prove it, right? So you're raising an issue by filing a lawsuit against a minor, right?
Yes.
You have to prove that there's a case or controversy because you filed a lawsuit. You can't have a live controversy against an incompetent. So what do you have to do? You got to make them competent to handle your case because you raised the issue. See, it kind of falls back on that default rule. If you raise an issue in any court, you have the duty to prove that you have the right to be there. Yes, ma'am.
So, just one more question. I got my divorce in Maryland, and we were required to have a guardian ad litem for our children.
And you had to actually get him served before he had to answer, didn't he?
So is that what happens here when people get divorced? They have to have a guardian ad litem for their children?
Not always.
Okay.
If there's allegations of abuse or neglect, then sometimes the court will do it.
Right.
And if the daddy comes in and says, that's not my child, they automatically do it.
Oh, wow. Yeah. So they just made us there.
Yeah, well, that's their practice, but Alabama does not automatically do it. Yes, ma'am.
So, just so I'm clear, it's not just heirs that can reopen closed estates and probate, it's also plaintiffs. They can force an opening after 30 days.
I don't know. If there's not an estate open, if there's not, then you can have an administrator ad litem appointed, which is not opening an estate, it's just appointing somebody in that lawsuit to defend the estate only for that litigation.
Okay, so.
You're not opening a general estate.
Okay, thank you.
Does that help?
Yes.
Yes?
I just had a random question. Since state of Alabama is no longer doing marriages, how does that work?
I have no clue. You know, if it were me, I'd say that if all I have to do to get married now is file a contract with probate, then all I have to do is go and file a statement saying, I'm no longer a party to this contract. But I don't know yet because I haven't seen any results of it yet. Yes, ma'am.
I have a question. I don't know if it complicates things, but so if you're trying to get money or look at a person's estate, but they don't have anything for their children, it's been rolled off to their children, how do you go about it that way?
Well, if it's been willed to the children, then they do have an estate.
Okay.
But if they had a smart attorney, they had them give it all away before they died, so that there's nothing for creditors to come in and make a claim against. That's if you name beneficiaries and transfer on death or payable on death.
Also, that's how you.
But you can learn that in wills and trusts. Okay, what was, somebody else had a question. Ms. Hethington, was that you? Okay. Have y'all got this real party in interest? Guardians ad litem. That's how you say plural of guardian ad litem. Only for the litigation. Now, can a guardian ad litem appointed in one case go and file another case?
Yeah, that's a marriage.
Isn't their authority only limited to the one case that they've been appointed on? Yeah. It's ad litem for a reason.
Who pays the guardian ad litem?
It depends. Sometimes in divorce cases, they'll order the parties to split the cost. Sometimes if they're court appointed, like for abuse and neglect the state pays it with that fair trial tax fund I talked about. And then sometimes if guardian ad litem is appointed in like a civil case for a car wreck to make sure that the settlement's fair to the child, then sometimes it'll be the insurance company defendant who pays for the guardian ad litem. So it depends.
It's just important not to be one.
We had to split $2,500 between the two of us.
In divorce cases, they typically split them.
It's just important not to beat yourself up.
And in a divorce case, if the daddy comes in and says, that's not my child, a lot of times the judges will make the party causing the guardian ad litem to be appointed to pay the entire fee.
That's what you got to do. Keep that law.
So,
The DA. You got to keep.
the elected DA. You're talking about Charles Todd Henderson. It was involving a guardian ad litem case, yes.
My ex-husband was going to try that. We got a divorce. We have 4 kids, and he was like, none of the kids was his. And they was like, okay, we'll do DNA tests, and we got to pay for every test. He's like, oh, they mine. They mine.
When they threaten to make them pay for everything?
Yeah, he changed his tune real quick.
They do. Because it's cheaper to just go ahead and admit they're yours. The fun one is when the husband and the wife separate. And I've got one of these going on right now. The husband comes to me like 2 or 3 years after they separate and says, it's time for me to finally file for divorce. And I said, you realize if she's pregnant again, that baby's yours. I haven't seen her in 3 years. I don't care. You're still married. So it's still your baby. And then a guardian ad litem will be appointed to make us do a DNA test to prove that it's not his child. And then hopefully to require the person who actually is the daddy to be named on the birth certificate. But that's all tied up in Rule 17, by the way.
And if you're voluntary, if both parties are okay with it, can you voluntarily get rid of the rights?
Alabama's got a public policy against bastardizing children.
They don't do it though. But if there's a daddy in place, they will do it.
They'll do it if they have somebody else to come in and step into the place.
Why? Why would you do that? They would rather keep people who don't want the kids in the picture instead of just.
Let me tell you, ex parte MDC, just in case any of y'all are wondering, if you want to voluntarily terminate your parental rights, you can do that. But ex parte MDC was the case, the opinion was by Justice Boland, that says even though you have your parental rights terminated, you still owe child support until the child's adopted. So,
And you still have to pay your arrears.
and your arrears. All right, let's move on. Let's move on to Rule 10. 10. There's a handout. All right, the handout that you now have in front of you. I prepared this many, many years ago, back before a couple of rule changes. So as we go through Rule 10, you're going to have to make a correction or two to this handout. So let's start off with Rule 10A. Rule 10A, this is form of pleadings. You have to have a caption and name of parties. Every pleading must have a caption with the court's name, a title, and a file number, and a Rule 7A designation. Have to have a court's name, a title, a file number, and a Rule 7A designation. So look at your handout. Across the top of the page it says in the, and then it says name of court, or something similar to that. Now, traditionally, you put the name of the court across the top of the page. And this is going to be the same whether or not you're in state court or federal court. In federal court, you put in the, and then you say United States District Court for the Northern District of Alabama, and then sometimes underneath that you'll actually put what division it's in, like the Southern Division. That's the name of the court. The title is going to be the names of the parties on the left-hand side of that column. It's P1, plaintiff versus D1, defendant. Except that on a complaint, you have to list every plaintiff and every defendant. You have to list every single name.
Just the complaint.
Just the complaint. For every other pleading or other paper, all you have to do is put the name of the first plaintiff, and an appropriate indicator indicates to the court that there's other parties. Quite typically, it's going to be et al. Remember, et al. Is our Latin phrase that means and others. Or in some instances, you may want to be fancy and put et ux. Remember et space ux. It means and spouse. Y'all remember Troxel v. Granville? Have y'all studied that one? Oh, it's about parents' rights to decide who children spend time with. Yeah, it's Troxel et ux, which means Troxel and spouse, versus Granville.
Oh, that was the grandparents, right?
Yeah, grandparents.
Okay. Yeah, that was a little unconstitutional.
It was, but the names of the parties were still et ux because it was their spouse. And so et al. For and others, or et ux means just their spouse. I don't know any other fancy Latin phrases for you for this. And then defendants, you have to list out all of them on the complaint, and on any other pleading or document, you only have to list the first one, again with the appropriate designator. Then 10A says you have to have not just the title, but a file number. Typically, you put civil action number, and since you don't know the number of the case before you file it, you usually just leave a blank line or a blank space there for the court to stamp it with your file number on it. And then the last part is a Rule 7A designation, which is going to be one of the pleadings that listed on our chart. It's either going to be a complaint or an answer, or a counterclaim and an answer to a counterclaim, or a cross-claim or an answer to a cross-claim, or a third-party complaint or a third-party answer, or it's going to be a reply to one of the answers above. So that's what your pleading has to look like. It has to have that on there. Now, why do you think you put the name of the court and the names of the parties and the file number on each paper? The initial document. Well, let's just say I'm walking through the courthouse and I see this piece of paper on the floor and I pick it up. I say, oh wow, how nice, it's a piece of paper. Where does it go? I look at the top and I see the name of the court. Oh, it's in the right courthouse. I see the names of the parties, doesn't really matter to me, but then I see this file number. I can take this document to the clerk's office and say, hey look, I found this in the floor. It probably belongs in a file. Would you please put it in the proper file? And they can take that piece of paper and find out exactly where it goes. Now that's back in the old days. Now we do electronic filing, When you leave the blank here, usually it's going to put either a stamp in the upper right-hand column or sideways down the left-hand side. It's going to have the name of the court and the case number on it and the date and time that you filed it, so they'll know exactly which file it goes into. Either way, it complies with Rule 10A because it's got the name of the court, the names of the parties on the paper, the case number or the file number, as well as one of those designations in Rule 7A, because those are the only pleadings that are allowed. And if I were to ask you a question, which one of these pleadings is not allowed, and I have complaint, answer, third-party interpleader, and a reply to an answer, there's no such thing as a third-party interpleader in Rule 7A. You need to know the list of the types of pleadings that are allowed under 7A. Even though it says an answer to a counterclaim, counterclaim is implied. You've got to have a counterclaim before you can have an answer to a counterclaim. But other than that, it does list inside Rule 7A all the different pleadings that are allowed. Now back to Rule 10. 10A says the title of the complaint must name all the parties. The title or other pleadings after naming the first party on each side may refer generally to other parties, which is your et al. The complaint has to list everybody. Every other paper doesn't. Letter B, a party must state its claims and defenses in numbered paragraphs, each limited as far as practicable to a single set of circumstances. Well, if you want to put a single fact, it's better, not just the circumstances, but a single fact, and then list each separate fact out that's going to establish your claim. A later pleading may refer to a number to a paragraph in an earlier pleading. Who asked that question? So there's where you can refer to it by paragraph number when you either admit or deny it. If doing so would promote clarity, each claim founded on a separate transaction or occurrence, and each defense other than a denial must be stated in a separate count or defense. We'll look at your handout. You see where I've got claim 1 in there? That's where you would list one transaction or occurrence. You put your first claim. Then there's a spot down there where you can put claim 2, and then after that claim 3, and after that claim 4.
Do you write claim 1?
I usually put count 1, count 2, count 3, count 4. But the idea is that you're putting each claim in there separately spelled out claims. Now, let's use an example. Flip over real quick to Rule 8. In order to state a claim for relief, since we're on the claim portion of our handout, Rule 8A says a pleading that states a claim for relief must contain, number 1, a short and plain statement of the grounds for the court's jurisdiction. You remember week 2, we gave you statute numbers? Well, the 3 that you're going to be mainly interested in federal court are 28 U.S.C. section 1331, 28 U.S.C. section 1331. Y'all remember what 1331 is? It's a federal question. Or 28 U.S.C. section 1332, diversity, or 28 U.S.C. section 1367, supplemental. So when you put claim 1 in your complaint, and your claim is based on a federal question, you say this, paragraph number 1, this court has jurisdiction to hear this case pursuant to 28 U.S.C. 1331 because this is a federal claim. Paragraph number 2, you start setting out your federal claim. If it happens to be diversity, paragraph number 1 is going to be this court has jurisdiction to hear this case pursuant to 28 U.S.C. section 1332 because this is a diversity claim. List the statute telling the court how they have authority. That's the first thing you put in federal court. And that's Rule 8A. that tells you this is what you have to get a claim in federal court. Now, look at 8A2, a short and plain statement of the claim showing that the pleader is entitled to relief. A short and plain statement of the claim. All right, since I had all of the contracts last year, what do you have to have in a complaint to put forward a claim for breach of contract?
Offer, acceptance, consideration.
Paragraph number 2, because number 1, this is a diversity claim, right? Paragraph number 2, there's a contract between the plaintiff and defendant. Paragraph number 3, plaintiff performed their duties under the contract. Paragraph number 4, defendant breached their duties under the contract. Paragraph number 5 is what? Because defendant breached, plaintiff suffered damages. It's real simple, right? Now, if you go to paragraph number 2 and you say they entered into a contract, do you want to have paragraph number 2A say that the contract is spelled out as follows, and then you type every bit of the contract in? Why don't you want to do that? Yeah, number 1, it says a short and plain statement, right? So is it short and plain if you type out a 28-page contract? What do you think would be easier to do? See attached, right? That's Rule 10C. Rule 10C is that says that you can make a reference to an exhibit and incorporate it by reference. So in paragraph number 2 of this complaint for breach of contract, plaintiff and defendant entered into a contract, a copy of which is attached hereto as Exhibit 1, and incorporated it by reference as if fully set out herein. So you don't have to type the whole thing out. Now, does that make it real simple? Now, as a defendant, when you look at that paragraph number 2, and you say, we entered into a contract, and then you flip back to Exhibit 1, and you look at it and says, yeah, that's our contract. Makes it real simple for them to go in and say, defendant admits the allegations in paragraph number 2. Separately numbered paragraphs, and that goes back to 10A or 10B, separately numbered paragraphs. They can be referenced by paragraph number. And then 10C says you can incorporate documents by attaching them as exhibits. All of that's part of this handout. Yes, ma'am. Plaintiff performed, defendant breached. And you know what I just gave you? The elements for breach of contract. Now, have y'all had torts?
Yes.
You know what the tort of negligence requires you to prove? Let's go over it as far as Rule 8 is concerned. Rule number 8A says, short and plain statement of the jurisdiction. So what do you have to say? Paragraph number 1, this claim is brought pursuant to 28 U.S.C. section 1332 as a diversity claim. Paragraph number 2 is what? Defendant owed duty to plaintiff not to injure them. Paragraph number 3, defendant breached the duty. Defendant number 4 is, or paragraph 4, causation. Paragraph number 5 is harm. So duty, breach, causation, and harm. For a negligence case, contract, plaintiff performed, defendant breached, and damages for your breach of contract. And we'll probably use those examples through all of these 2 semesters because they're the simplest causes of action to remember. Breach of contract and negligence. So I have now finished up one claim in my paragraph and I say I brought it pursuant to diversity, right? Now, what if, let's go back to our example. The plaintiff wants to file a claim against 2 foreign, non-Alabama defendants. Now I've got diversity. And they want to bring 2 claims against the electrician and 2 claims against the plumber. Claim number one, the plaintiff wants to bring against the electrician is breach of contract. Paragraph number one of claim one, this is a diversity action. Paragraph number two, which is starting off your claim for breach of contract, there's a contract. Paragraph three, plaintiff performed. Paragraph four, defendant breached. Paragraph number five, I have damages as a result of the breach. Claim two, I want to bring a negligence case against the electrician. Paragraph number one of claim two is going to be, this is another diversity action. Or, technically, you could say, I'm bringing this one in under supplemental. Because now that you've established that you've got jurisdiction on one claim, you don't have to establish jurisdiction again. You can just bring it as a supplemental claim. Remember the piggyback? Only the first claim's got to get your foot in the door. All the rest of them can be supplemental. And so there's your paragraph for negligence. Either supplemental or diversity again. Duty by the defendant, breach by the defendant, causation of the injuries and harm. And that is claim 5, or claim 2. All 5 paragraphs for claim 2. Yes, Mr. Francis?
Something caveat about jurisdiction. You got your foot in the door, the first claim. But what happened with jurisdiction?
Paragraph number 1 of claim 2, I can either say it's another diversity claim, or I can say it's supplemental because I've established diversity in the first one.
So can I get flexible about jurisdiction on the other one?
Sure. You can say I bring it either pursuant to diversity or supplemental. The court's got jurisdiction to hear it both ways. Pick which one you want, court, because it doesn't matter. You're going to hear my claim. Right? Now, let's get back to the handout. The next thing you see in your handout is this wherefore paragraph. If you look back at Rule 8, Rule 8 says that you have to have a demand for relief. This is 8A3. A demand for relief sought, which may include relief in the alternative or different types of relief. So our wherefore paragraph is actually required by Rule 8A3. It says 8A3. Wherefore plaintiff demands judgment against defendant for, and then in braces it's the relief you seek, whether it's money, whether it's damages, injunctive relief, whichever one that you're actually entitled to, and then look at the rest. And such other further or general relief to which the plaintiff is or are justly entitled. Remember on the back of 8A3 it says any other alternative remedies that you have? Well, that's a catch-all, because what do you not get when you file a lawsuit? You don't get anything you don't ask for. So what do you want to make sure you do in a lawsuit? Ask for everything to which you're entitled. So if at the end you put any and all other relief to which we're justly entitled, then you've asked for it, even though you don't spell it out. Mr. Cash?
Yes.
We're sweating.
That's what I understand. That's why I'm here.
Okay.
Working on it. I knew we had one of these in the building and I robbed it from one room. I'm just curious to see if our interface will jive with what this says. I'll just put it right here.
Thank you, sir. All right, now let's get back to our wherefore paragraph. There's something else you need to know about the wherefore paragraph that you need to be able to put in there if you need to put it in there. And that is the relief that you're requesting that the court give you. There's 2 types of damages that are normally associated with cases. One of them is called general damages, and the other is called special damages. And here's what you need to know about the 2. General damages are those types of damages that you would usually expect to occur from a particular transaction or occurrence. Types of damages that you would usually expect to occur from a particular transaction or occurrence. let's talk about a car wreck. What type of damages would you expect to occur in a car wreck? And we'll go through a list and you tell me yes or no.
Damage to the vehicle.
Property damage, yes or no? From a car accident. Property damage?
No.
No? Somebody rear-ends your car.
You're talking about car damage or physical land?
I'm talking about property damage. Do you have property damage to your car if somebody slams into the backside of it? Yes, that's general damages because you usually expect there's going to be some type of damage if somebody runs into your car. It's general because you usually expect it to occur from that type of injury. How about work time loss?
Yes.
You would normally expect that you're going to have to take some time off because you don't feel so good after a car wreck. How about medical bills?
Yes.
Yes, normally you would expect medical bills. How about to replace the wedding cake you were transporting to the wedding?
Maybe this special.
You know how much they weigh.
Do you normally expect to run into somebody driving around with a wedding cake?
No, but this will still be covered though.
It should still be covered. So here's the difference. For your general damages, in your wherefore paragraph, or even in your other paragraphs that says, I experienced the following damages, for general damages, you don't have to list those out. Because due process says you're given fair notice of the damages. Well, if they reasonably occur from whatever happened, you don't need notice of special damages because those are the types of damages you would normally have. But for special damages, those that aren't normally the type of damages that would occur from a transaction or occurrence, then you have to list those out to give due process. See, we said due process pops in everywhere. So, property damage to the wedding cake that you were transporting?
Yes.
Total loss? Yes, you are entitled to list it out, but is that a general damage? No, it's a special damage, right? So, you don't have to list the property damage, the medical bills, the work time loss, but do you need to mention the damage to the wedding cake? You got to put the wedding cake specifically in there as damage. Now let's use another one. Auburn's playing today, right? What if my friend Bo Jackson loaned me his Heisman Trophy to take down to Jordan Hare this afternoon, and on my way down 280, I get rear-ended?
Well, we're actually playing at Ben Hill Griffin.
They're playing where?
Ben Hill Griffin, the swamp.
Oh yeah. Okay, so I'm on my way down to Tallahassee. Gainesville. On my way down to Gainesville. And as I'm going up to one of those toll booths, somebody thinks they're in a SunPass lane and they don't slow down, they run right into the backside of my car and tear up Bo Jackson's Heisman Trophy. Now, the property damage to my car, that's general damages. Tell me if these are general or special, okay? Property damage to the car? Medical bills? Pain and suffering?
Yes, general.
Okay, y'all got it. That normally occurs. A replacement Heisman Trophy?
Special.
That's special because you don't expect that to be in my car. Now, what if it's Bo Jackson's car? Do you expect it to be in his car?
Yes.
No, you don't expect
Right, like it's short.
But it doesn't matter. It's what ordinarily happens in that type of circumstance, transaction or occurrence. So you don't expect wedding cakes or Heisman trophies. So what you got to do is you list them out. Now, if there is a question as to whether or not it's general or specific, list it. Because if there's a question as to whether or not it's general or specific, list it to err on the side of caution. Because better to give them notice of something than to not give them notice and to give them a way to attack your judgment, right?
I wonder, would the University of Auburn have a claim since they paid for that time?
It's Auburn University.
Oh, I'm sorry. Would the University of Auburn have
Well,
a
the car's being stolen by an elemental football player.
All right, so y'all got Rule 6. You're in Rule 8, right? We're covering Rule 8A, so put Rule 8A in your notes. Now flip over to Rule 9. Rule 9 is pleading special matters. And general damages are special damages is 9G, where you do have to plead special damages with particularity. You have to list out your special damages. But then there's also a couple of other times where you have to list special matters like fraud. If you want to allege that there's fraud, you have to put particularly in your complaint how the fraud occurred. Now what about mistake? Y'all had contracts. What is a mistake?
If it's a mutual mistake.
If it's mutual, then there's no contract, right?
Right.
So what do you usually have to plead in your complaint?
Unilateral.
That it was a unilateral mistake and there's a contract and they breached it anyway, right? So you see how they want to have certain things pleaded particularly. Conditions precedent. Remember on our breach of contract we say plaintiff performed, defendant didn't. That's because plaintiff's performance is a condition precedent to an actual defendant's breach. And then conditions of mind, you don't have to plead those, and you don't have to plead capacity or incapacity. Not with particularity, but it's usually fraud, mistake, and special damages are the big three that you have to plead in particular in a complaint. Now, there's case law, and this case law goes back to 1953. 1957. Rule 8 has often been called notice pleading. That's the term for it, is notice pleading. You give them notice of the cause of action and the facts that surround it. In fact, it says, in this case is Conley v. Gibson. This is U.S. Supreme Court case from 1957.
What's that case again?
Conley v. Gibson. It's in your reading assignment. It says all the rules require is a short and plain statement of the claim that will give the defendant fair notice of what the plaintiff's claim is and the grounds upon which it rests. And they call that the notice pleading standard, which they have always called Rule 8 the notice pleading standard. Now, that was all good for 50 years until this other case, Twombly versus Bell South, I think. And it was a securities case that went all the way up to the U.S. Supreme Court. And the U.S. Supreme Court in that case said, yeah, notice is one thing, but we need a little bit more in this case. And this, by the way, is going to be your reading assignment for tonight. It's in your textbook, your casebook. So the Supreme Court in 2007, yes ma'am?
The notice pleading standard Rule 8 are talking about the state law?
Both. As it turns out, Alabama Supreme Court adopted Conley v. Gibson, which said Alabama's Rule 8 is also notice pleading. But then the Supreme Court changed Rule 8 in 2007. But the Alabama Supreme Court said, or the Alabama Court of Civil Appeals said, our Supreme Court has adopted Conley v. Gibson, and they've not overturned it, so we're going to continue to use notice pleading. So here's where the federal court diverged from notice pleading, and that is tell them what the claim is and the facts that support it. Well, in Twombly, they said, well, you haven't quite given us enough. You got to give us more detail about how this happened so that we know whether or not your pleading states a plausible claim, one in which we think that you might be able to recover. So in 2007, right after that came out, and in 2008, a bunch of legal scholars started giving their opinions on what they thought that meant. And these law review articles started saying that now notice pleading is no more in federal court. Now it's plausibility pleading, where not only do you have to plead a cause of action, but now it has to be pled in such a way that if it's plausible, if you can prove that, then it's plausible that you might recover. Not necessarily probable, but it's plausible. And they've started using that to throw out cases. One of the first of them was Ashcroft versus Iqbal. That's John Ashcroft, the Attorney General, versus Iqbal, Iqbal. And that case was a Guantanamo Bay case brought by one of the detainees who had been abused at Guantanamo Bay. He didn't know who it was that abused him or how they did it, but he was injured. But he wanted to have redress. And the Supreme Court in that case came back and said, no, when we said back on Twombly that Rule 8 requires more than just notice, it requires you to set out more detail, then because Iqbal didn't know who, how, and what did what to him, they said, oh, his case is thrown out because he didn't give us enough details. So let's go back to fraud. If you allege that somebody conducted a mail fraud on you, but you don't know who it was that actually mailed the letter or where they mailed it from, all you know is you just got this letter in the mail and you sent in money. Have you stated a cause of action which it's plausible that you could win? Yes. Well, it's a mail fraud. That is a cause of action, right? But if you prove only what's in your complaint, is it plausible that you can actually win? No, it's not. You gotta have, well, discovery is how you get the details and facts. That's what Tommy B. Gibson said, is notice pleading puts you on notice of what the claim is. Discovery allows you to fill in the details of how it happened. But now the Supreme Court's gone back in and said, oh, never mind. You don't have the opportunity to do your discovery. If you don't know what it is at the very time that you file your complaint, then we're going to throw it out because you didn't state a plausible claim. Well, that's yet another bouncer at the federal court trying to keep you from being able to get redress in the federal court. That's called the notice pleading bouncer. And they went so far as to say, no, we haven't changed the notice pleading. It's still notice pleading, but it's notice pleading plus. But all the commentators call that plausibility pleading, that if you don't plead something that's plausible, they're going to throw your case out. And then not only is it Conley, but Bell Atlantic versus Twombly is 07. And then Ashcroft versus Iqbal, Iqbal, is 2009. And so for the past 10 years, federal courts have been throwing out cases because people haven't been meeting this heightened pleading standard, which means to me, you need to be able to find a way to plead something and put it in state court and keep it from being removed to federal court. And there's an actual term for that. It's called the well-pleaded complaint rule. Now, how do you think you do a well-pleaded complaint? You make sure you don't have diversity, right? And you make sure you don't have a federal question. Because if you make sure you don't have either one of those, then the federal court has no jurisdiction to hear those cases. Now that brings us to Rule 21. Rule 21 is called misjoinder and non-joinder. Getting back to our joinder cases. What do you think a misjoinder is? You brought in the wrong person. So what do you think non-joinder is? You didn't bring in a person. Now what about maljoinder? Yeah, you brought them in wrongfully. So why might you bring somebody in as a party that you really don't have a claim against? To destroy diversity, right? So you bring somebody in who's from a different state or from the same state in order to keep the federal court from having diversity. Now, what does the federal court do with that? Well, sometimes if they throw that party out, then they have diversity and they keep the case. But under the well-pleaded complaint rule, remember, who's the master of the complaint? The plaintiff is. The plaintiff's the master of their complaint. They get to pick and choose all the claims under Rule 18, all the parties under Rule 20, as long as they get all the ones that are required under 21, and don't add the wrong or omit adding parties under 21. Let's see, it's 18 for claims, 20 for parties, 19 for parties required, and 21 for misjoinder and non-joinder. 18 for claims, 20 for parties, all the parties you want, except that 19 requires that you add all those that are necessary for a just adjudication. And then 21 is misjoinder and non-joinder, so you don't have wrong parties, and that you get all of them that are required.
Defendants controlling people with disabilities?
Yes, that's under 14. Rule 14, third party practice. Hey, Dean. It's actually getting a little better. I'm starting to feel it cool down.
Mr. Mayor.
Yes.
You said before the well-pleaded complaint in the federal courts have been thrown out. Before the well-pleaded complaint.
Heightened pleadings. More than just notice. It's either the notice plus or the plausibility. Now, look back real quick at your form, your handout. And here's one of the corrections under Rule 11. You see the signature place at Rule 11? It says you have to have the signer's name, address, telephone number. You also have to have the email. They've added email here since I did up the form. So right underneath the telephone number, write down email. Now look also at Rule 11. Every paper has to be signed by the attorney, or if there's no attorney, by the party. That's Rule 11A. And then if you happen to turn in a paper that's not signed, and the court brings that to your attention, you better go sign it, or otherwise they'll throw your case out. That's also in Rule 11A. Now Rule 11B is the certifications that you're making to the federal court whenever you sign a piece of paper. Representation number 1, it's not being presented for any improper purpose, like to harass, cause unnecessary delay, or needlessly increase the cost of litigation. No improper purpose. Now, can you file a motion to continue under this rule?
If there's legitimate reason.
If it's not a needless delay, right? If there's a legitimate reason to continue, then it's not a violation. Look at certification number 2. The claims, defenses, and other legal contentions are warranted by existing law. That's the first part of it. Or by a non-frivolous argument extending, modifying, or reversing existing law, or for establishing new law. Now, y'all know what frivolous is, don't you? It's not grounded in law or fact. So how do you bring a cause of action to create a new cause of action in court? I'll give you an example. What about you want to file a lawsuit in Alabama for tortious interference with an inheritance? Alabama doesn't recognize that right now, but maybe they ought to. Don't you think? And what if it's you who your spouse or who your sibling took the money from? That instead of y'all dividing everything equal, your sibling now gets 100% and you get nothing.
Find cases from other jurisdictions, does it change?
Find cases from other jurisdictions?
Persuasive, or legislation.
Persuasive. Maybe there's legislation, but if there's legislation that says now there's a cause of action for it, that's a new cause of action. It's supported under the current law. Yeah, find persuasive authority. How about this? A new cause of action. What if tortious interference with an inheritance happens to be a cause of action that's listed in the restatement of torts?
Let's bring it up.
Heck, it's recognized as a tort. Let's go ahead and have it recognized here in Alabama. Is that a non-frivolous argument? Yes. Well, your classmates think it is. If it is a recognized tort, but you want to have it to be officially recognized in Alabama, you can make the argument that it's non-frivolous. Now, what if your client's the one who stole the money from the sibling.
We want to argue it's very frivolous. Kind of the most frivolous thing I've ever heard.
All right, what about a good faith claim to reverse a current law?
That's not frivolous.
Yeah, I would think it's not frivolous either. What about challenging the constitutionality of unlawful possession of marijuana in the state of Alabama?
Well, that's frivolous.
That's frivolous.
Well, could you argue
Could
that?
argue that it's not.
Could you argue now that 38 states have legalized it in one way or another?
Well, it's like arguing that contributory negligence should be dismissed when only Alabama and 3 other states use it. Alabama's like, well, we don't care what other states do.
Yeah, you can make it. You can make an argument to get away from contrib and go to comparative because every state but 3 recognizes comparative rather than contrib. Can you make that argument as non-frivolous?
Yes.
No, 47 states recognize comparative rather than contrib for negligence. All right, here's the way where a number of people get in trouble. It's certification number 3. The factual contentions have evidentiary support, or if specifically so identified, will have evidentiary support after a reasonable opportunity for further investigation and discovery.
You're just throwing crap out there.
It's a fishing expedition, isn't it? We think that it'll have evidentiary support. Do you really think that there's going to be evidentiary support?
If you make a good faith, you're hoping. I mean, if it's in good.
Well, if you say, I hope there's evidentiary support out there, is that more honest?
Yes.
Better than I think there will be? I hope there will be? Is I hope there will be plausible?
I'm guessing.
I hope there will be is not even plausible, right? Is I think there will be plausible? It's better than I hope, right? Don't you agree? All right, and then the last one, the denials of factual contentions are warranted based on the evidence, or if you say you don't have the information. So those are the certifications in federal court that you're making every time you put your signature to a piece of paper. And by the way, if you don't actually believe that, look at 11C, sanctions. And federal courts are real good about imposing Rule 11 sanctions. If you violate one of the representations, the court can make you and or your client pay even the attorney fees of the opposing side. There's a Rule 11 in state court as well. However, the Rule 11 in state court, because the judges are elected, they don't often assess sanctions against attorneys. But if there really is a need for it, the Alabama legislature has recognized that the courts aren't good about awarding sanctions, so they passed a new law many, many years ago. It's called the Alabama Litigation Accountability Act, which creates a new cause of action for you to recover your attorney fees and costs if they raise something without substantial justification. So it's a backdoor to Rule 11. Now, almost down to the end of our form, our handout. The next one is a jury demand under Rule 38. Rule 38 says the right to a trial by jury shall remain inviolate. And then 38B says only if you file a demand does it remain inviolate, because if you fail to raise it, it's waived. It's waived. So what you can do on your pleading, your initial pleading, is if you want a jury trial, tell them you want a jury trial, actually on that same document. And then that way you don't lose your client's right to a jury trial.
What was that?
38.
Can the attorney waive that for the client in civil?
Yes,
Yes.
they can. Now, the other thing about Rule 38, if you look at it, it says that you can demand a trial by jury on whatever issues that you want to have trialable by jury. Well, there's usually 2 issues in every jury case. Anybody want to guess what those are? Guilty or not guilty. That's called liability. And then what's the second jury issue? How much money? So liability and damages. If in your jury trial you only want the jury to determine damages, you can say plaintiff demands trial by jury on the issue of damages alone. And then the only thing the jury's going to decide is your damages. If you want the jury to decide liability alone, you say demands trial by jury on the issue of liability. Or if you wanted to decide both, you can say demands trial by jury on issues of liability and damage, or on all issues, or just demands a trial by jury. And that's enough to preserve it, as long as you have a written demand for a jury trial.
You said it's Alabama.
Both. And then the last thing on your form, since I've got 5 minutes to wind up, is your notice to the clerk of court as to how you want the summons and complaint to be served. I just ran across a case from Alabama, under the Alabama rules, that says where you omit to put instructions to the clerk, then it shows that you did not intend on prosecuting your case, and then they threw it out.
Is that rule 4?
That's rule 4, where you give notice that you want to have them served in a particular way. In state court, you can do certified mail by the clerk or certified mail by the filer.
You don't give them a way to serve it, it's like basically lack of prosecution.
Lack of prosecution. So you always want to put a notice to the clerk, I want this to be served by private process server, or you can put a note on the bottom of yours that says, we'll attempt to serve by waiver of service. Just as long as you're letting the court know you're actually doing something to prosecute your case. So you don't give the opportunity that says you intentionally delayed the case, because if you file it the day before the statute of limitations runs, but then you don't bother to attempt service for 2 weeks, can I now come in and make an argument that you violated my due process by not taking diligent steps to serve within the statute of limitations? See? There's where you come up with your arguments. All right, I'm going to leave this chart on the board in case any of you want to take pictures of it. Free to put that in your notes. The summary to turn in for next week is everything we've covered this week. The good news is next week's lecture is going to be less material, because next week you've got some sort of social after hours that the law school wants y'all to participate in, so I have to make that announcement. It's easier for my Thursday night class, because if I finish early, they leave to go over there. But it's the same material Thursday and Saturday, so y'all get the benefit of a shorter lecture. Give you time to study for your midterms for your other classes.
We get to go to lunch.
Yeah, or you can go to lunch.
You're keeping us awake.
All right, have y'all, anybody come in after I call the roll, please come see me so I can get you on roll. Otherwise, y'all have a great weekend.
Where I screwed up on property, I should not associate property with land.